Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to discuss the National Labor Relations Act. And if you think that only applies to union people, you might want to think again and stick around. I'll be back in just a moment. Now, lots of people seem to think that the National Labor Relations Board is only there to protect union members. And indeed, one of its primary functions is to protect union workers, to ensure that they have a right to organize and act together to assert their rights and get better pay and better benefits, and to basically be good employees while at the same time taking care of themselves. The NLRB, however, has in some areas become sort of a haven for the really bad employee. I had a case several years ago where a person who worked at a hotel was essentially planning on leading a walkout, but management had no idea that they were planning on leading this walkout. What they did know was that this particular person had such a terrible work record and had such terrible job performance that they really wanted to get rid of this person. So they fired the worker, and she brought an NLRB complaint, and the complaint was processed. We took it to trial. We put in all these witnesses who showed what a terrible employee she was, and we lost anyway. We came out of that feeling a lot like maybe the whole deck was stacked against the employer. I don't know that for sure, but that was certainly the way that I came out of it. We took it up to the Eighth Circuit Court of Appeals to obtain, essentially to get relief from the enforcement action, and the Eighth Circuit Court of Appeals simply rubber stamped what the NLRB had done, irrespective of the multiple violations of evidence rules and that sort of thing. It was really sort of a disheartening experience. But one thing that it did do is it taught me that there are a lot of protections for your average employee in the National Labor Relations Act. And no, you don't have to be a union member. For example, here is what the NLRB says on its website. The law we enforce gives employees the right to act together to try to improve their pay and working conditions with or without a union. If employees are fired, suspended, or otherwise penalized for taking part in protected group activity, the National Labor Relations Board will fight to restore what was unlawfully taken away. These rights were written into the original 1935 National Labor Relations Act and have been upheld in numerous decisions by appellate courts and by the U.S. Supreme Court. And on their website, they go on to list a few notable cases. I think it's really helpful to take a look at some of these cases because they illustrate just how broad the protection is under this particular statute. Let me talk first about the diaper lady. There is a company called Cotton Babies, and they make cloth diapers. Now, if you were like me and you thought that Pampers put cloth diaper makers out of business, well, you're wrong. There are a lot of people who think that cloth diapers are far superior to the kind you throw in a landfill. And certainly from an environmental perspective, I suppose that's true. They just are a great deal messier, and as someone who did not enjoy that phase of parenting, I personally was not very interested in cotton diapers. But a lot of people are. And Cotton Babies was a company that had an employee by the name of Giselle. And this is Giselle's story here. Giselle O., the customer service representative, frequently discussed work-related issues with her close friend, who was also her supervisor at Cotton Babies, an online cloth diaper supplier. Through one discussion, the supervisor learned that she was earning less money than Giselle, and she quit. The company owner told Giselle that she broke the handbook rule that forbids employees from discussing their wages with each other, and that in order to keep her job, she would have to reread the handbook and sign another form agreeing to its rules. Well, I worked in a lot of hospitals, and there was always a prohibition in the employee manual that said, you cannot discuss your wages with other employees. You can't tell another worker what you are making, because if you do...
What he means is Old Testament, Mr. Mayor. Real wrath of God type stuff.
Exactly.
Fire and brimstone coming down from the skies. Rivers and seas boiling.
40 years of darkness, earthquakes, volcanoes. The dead rising from the grave.
Human sacrifice, dogs and cats living together.
Well, unfortunately for most employers, that rule is completely bogus. You can't have it. So what happened? Giselle refused to sign, and 2 weeks later she was fired. After an investigation, the regional director found reasonable cause to believe that Giselle was unlawfully fired because she had discussed her wages with another employee, which is protected activity under the National Labor Relations Act. The regional director also found reasonable cause to believe that some parts of the handbook contained unlawful rules and issued a complaint. Now, a complaint basically says to the employer, we're going to take you to a National Labor Relations administrative hearing, and we're going to cite you for having an unlawful work rule. So what happened? Well, the NLRB tells us. The employer then engaged in mediation and reached a private settlement with Giselle, who received full back pay for the time off work and an offer of reinstatement, which she declined. The employer also agreed to change its handbook, adding a section that tells employees they have a right to talk with each other about their raises, wages, salaries, and other conditions of employment. Well, that was a good result, and the employee was quite happy with the result. Now, one of the things that does happen a fair amount in these NLRB cases is that you have the right to demand to be reinstated into your job. The question arises, though, as to whether you really want to be reinstated into a job where you have backed the employer into the corner and made them, in this case, change their very rules. Do you really think you have much promotion ability or promotion potential in a company like that? Probably not. So about 9 times out of 10, the employee will decline the offer of reinstatement and will instead take the money and run, which is probably a much wiser course. Now, the next case deals with a hospital. Now, you would think that a hospital would be someplace that would certainly grant its employees a lot of leeway on medical limitations. A lot of people have the belief that working in a hospital is somehow easy work. That basically you go around all day giving shots and smiling at patients, and that's really all there is to it. But particularly for nurses, nurses have a very demanding and physical job. You have to lift patients up in the bed because when they raise the head of the bed, they almost always slip down in the bed. So you'll wind up raising them up in the bed so that they are sitting on the more padded portions of their anatomy rather than on the end of their backbone, which can cause pressure ulcers. And sometimes you're a 90-pound nurse trying to lift a 200-pound patient. And that is no easy job. As a result, a lot of times workers, particularly nurses, nurses' aides, LPNs, that type of person, they tend to receive back injuries and back strains, and they wind up getting work limitations as a result of that. The employee health physician will tell the hospital, look, Mr. X here can't lift more than 50 pounds for the next 8 weeks. And a lot of times, even though employers are aware of those sort of restrictions, they still violate them. And apparently, that's what happened in this case. RML Specialty Hospital is a long-term acute care hospital in Chicago. It unlawfully suspended and discharged an employee for submitting a grievance concerning management's treatment of employees who returned to work from medical leave. Following a thorough investigation, the Chicago National Labor Relations Board Regional Office issued a complaint, and prior to hearing, the employee and the employer reached a settlement agreement which provided full back pay to the employee. Now, a lot of times it is very difficult for people to find out that they have these rights. And in this particular case, the employees went to a place called Arise in Chicago, which is an employee advocacy service. And basically, what happened was they helped the employee make this right. After submitting his grievance to the employee, one employee was fired. The Arise representative who assisted him with drafting the grievance had previously attended an NLRB outreach event hosted by the Chicago regional office. He informed the employee that he had a right to act concerted with his co-worker and the employer could not retaliate against him. The Arise representative helped him file a charge against the employer. So they filed a charge against the employer. Now basically what that is a formal document signed by the employee that goes up to the National Labor Relations Board's regional office. The regional office then asks for a bunch of information from the employer. That information will always include every bad thing that the employee has ever done. You know, if they had overdue library books in 5th grade, boy, that's going in there. Anyway, the employer sends all this information to the NLRB, which basically is just there that information request is just there to establish jurisdiction. They have to have a certain number of employees and they have to do a certain amount of business in interstate commerce in order for this act to apply. But assuming that they have all of that and they have sufficient number of employees, then the NLRB will send an investigator down to the place where all of this occurred and he will talk with the employees. Not generally in the workplace because the investigator wants to get the honest take and he doesn't want the employee looking over his shoulder. And that's because if the NLRB goes to the employer to conduct these interviews, the employer has a right to have their attorney present during that interview, and that simply does not jive very well with what the NLRB wants. So the NLRB does the investigation, and then, if necessary, they will file a complaint. The NLRB goes on about this particular case. Following an investigation of this charge, the regional director of the NLRB determined that the employee had engaged in protected concerted activities with his coworker and that there was reasonable cause to believe the employer terminated the employee in retaliation for his protected activity of filing a grievance. On behalf of the NLRB General Counsel, the director issued a complaint calling for a hearing before an administrative law judge. Prior to the hearing, the employee and the RML hospital reached a settlement agreement providing the employee with his full back pay. The employee declined reinstatement to his old job. Now, what do all of these cases have in common? Well, first, there are workers acting to protect more than just one person. Even if an individual is just having a conversation with another coworker, that's group activity, because when you have two people, that's a group. Now, most of us don't think of that as a group. Normally, we think of a group as a larger number of people in that. But the NLRB thinks of two people as a group. You have workers complaining about work conditions or invalid work rules. You have an adverse employment action, an NLRB investigation, and either a charge being filed or the employee sitting down with the employer at a mediation conducted by the NLRB where they agree that the employee will get their back pay and that they'll change their rules. One of the things that's very interesting about this is normally, in addition to the relief that the employee gets from the NLRB, back pay and that sort of thing, and an offer for reinstatement if they want it, there is also a requirement that they post a poster inside the employee workroom areas where the employees gather for breaks or lunch that tells the employees exactly what kind of rights they have to complain about work conditions and that they are protected by the National Labor Relations Act. It's one of those posters that every employee walks by every day on the way to the time card and on the way back to the time card at the end of the day, and they never read. Because if they did read, there would be a lot more of these cases. The National Labor Relations Act is a very powerful tool if you are an employee and you are unfairly treated because you are trying to improve your work conditions. It is, I believe, a little bit stacked against the employer. And perhaps that's good, because in a bargaining situation where you are asking the employer to do something for you, employees often don't have a great deal of sway with the employer. The only thing they can withhold is their work, and often the employer can go out and find somebody else to do the job. And that's true especially where there is not a union. Now, I am not a big fan of unions. I think in many cases, particularly in healthcare situations, they actually do more harm than good. But in factory work, particularly, I think they are a very good thing, and I think they generally protect employees in that setting. All of that said, you don't need to be in a union to use the National Labor Relations Act. So, if you have any questions, not only can you leave them in the comments down below, you can go to the NLRB's website online and check it out. And they have lots of information about what your rights are under the National Labor Relations Act. Or you can Google Protected Concerted Activity, and the National Labor Relations website will pop up. Thank you so much for watching, and I hope that today, particularly if you're an employer, you have an opportunity to be kind to your employees. And if you're an employee, you have an opportunity to be kind to your employer and to the customers, and of course, to your coworkers, because after all, they're your work family. So, thanks again for watching. I'll catch you on here next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.